Good afternoon, everyone. Okay. Good afternoon. It's now 2:20 and we shall recommence the inquiry. Mr. Village, you're due to re-examine Mr. Best.
Thank you very much indeed, Mr. Best. First of all, some questions relating to Mr. Robson's cross-examination. The issue of rebalancing, and I think that's probably cuts across both the council's case and Memoria's case. The issue as to whether rebalancing should be undertaken. Is there, in fact, in light of the questions you had, any dispute that, as a principle, rebalancing should be undertaken in appropriate cases?
No, I don't think there's any dispute that, in principle, rebalancing is an appropriate exercise.
If we turn to the Wergs decision, the Essington-Wergs decision, which is H11. H11A. First of all, what's the date of this decision, please?
It is 31st of March 2021.
March 2021. You were criticised for not having undertaken or rather not having suggested that rebalancing be undertaken in the needs statement which accompanied this application. I think, could you just turn up the needs statement? Do you have that to hand?
I do, yes.
What's the date of it?
August 2019.
You went slightly muffled there. August
2019.
Yeah. Before the decision of the Secretary of State in March 2021, had there been any decision of the Secretary of State or an inspector expressly endorsing the use of rebalancing?
Not that I'm aware of, no.
I mean, I think I perhaps ought to correct that question just a little bit, because I ought to say any decision of the inspector or the Secretary of State which survived challenge in the High Court, which because I think there was clearly in relation to the first Wergs, the issue of rebalancing was ignored by the Secretary of State, and that was one of the reasons why the decision was quashed. So, as at the date of the need statement in August 2019, was there a effectively an authoritative decision which actually considered and took account of rebalancing, so far as you're aware?
As far as I'm aware, no, there wasn't.
So, I mean, it may be, you see, that my learned friends, Captain and Lieutenant Hindsight, simply overlooked the fact that that this was not something that was in the public domain. But can I just see what the extent to which it clearly was something that the Secretary of State considered should have should wish to be considered? Could you turn to the WERG's decision itself, please?
Yes.
Paragraph 19 of the Secretary of State's decision letter under need. Do you have that?
Yes, I do.
And it says, overall, the Secretary of State agrees there's a substantial, if different, quantitative and qualitative need for both proposals, and that the latest evidence before him demonstrates this remains the case. He gives this significant weight. It was common ground between all the main parties, that's the Council, Westerly and Dignity, that at least one new crematorium is required to relieve pressure on Bushbury, and that this need amounts to very special circumstances that could outweigh the harm by reason of inappropriate development to the Greenbelt. For the reasons given at IR 13.48 to 1350, the Secretary of State agrees with the Inspector at IR 1350 that the consequences of chronic pressure at Bushbury would amount to very special circumstances, and also that taking account of the latest information on need and rebalancing, the need for both proposals, this proposal and the Essington appeal, has increased. He agrees with the Inspector that taking account of rebalancing, the need for both proposals means that very special circumstances exist to justify both schemes. Now, against that background of and authoritative decision made for the first time by the Secretary of State in March of this year, is it something that, in your view, rebalancing, is that something which can simply be swept to one side and ignored?
No, it's absolutely clear that just as need is a relevant consideration, so too is rebalancing. The final sentence makes that absolutely clear, that the Secretary of State agrees, taking account of rebalancing, the need for the proposals, the very special circumstances apply. So they're both apparent, and I think that it is particularly important where there's more than one proposal. In that case, there were two applications effectively before the Secretary of State, and in this case, there's an unimplemented permission and a proposal, and therefore the rebalancing is important.
Okay, would you turn now to the Inspector's report, please, in relation to WERGs? And under common ground on need, section 5, 5.12, it says the dignity evidence was that its scheme would relieve Gornal Wood as well as Bushbury, and that the Cannock Commission is likely to meet some of the demand at Streatley and Sutton Coalfield. Westerly's updated need report forecasts a greater demand than capacity and consequential rebalancing. its evidence was that through rebalancing, a reduction in pressure at Bushbury from its scheme would be likely to give rise to diversions from Gornal Wood. Dignity gave specific predictions for rebalancing, whilst Westerly addressed this descriptively. You were giving evidence for Dignity at that inquiry, is that right?
That's correct.
And you gave specific predictions for rebalancing.
Correct.
Westerly addressed it descriptively.
Yes.
Was there any criticism, so far as you can see, in the inspector's report of the Secretary of State's decision as to either approach?
Well, the requirement was agreed in principle. In relation to the specific way that I addressed it, my recollection, and we can go to there if you want, is that the inspector accepted that the forecasts were likely to be realistic, or words to that effect, but that there wasn't the body of evidence to support that, to give weight to it.
Yeah, but whether you should, for example, address rebalancing descriptively, was there any suggestion that that was wrong?
I don't think the inspector considered that to be wrong.
No.
I think as with need, there isn't a prescribed method or methodology. So they chose a different way, and that way was accepted as being valid in principle.
So can we just see what the inspector, how he addressed this at 13.7 in terms of rebalancing? Looking further afield, the council accepted that the work scheme would result in a reduction in pressure at Gornal Wood now and in the future. This would be partly as a result of rebalancing following an increased availability of time slots at Bushbury. It considered this should attract significant weight, but put it no higher than that. It saw no distinct benefits for Streatley Crematorium, but acknowledged there would be a compelling need in years to come. The council therefore concluded that the works would be preferable, as it would also reduce pressure on Gornal Wood. Dignity pointed to the pressure at Gornal Wood as being greater than that at Streatley. However, if, as the council suggested, some of the reduced pressure at Gornal Wood were to come about as a result of rebalancing from Bushbury, then the relief that Essington would provide to Bushbury would similarly benefit Gornal Wood, albeit indirectly. Rebalancing as a result of relieving Bushbury is likely to ease Gornal Wood, regardless of whether this comes directly from Appeal A or indirectly from Appeal B. And then 13.10, the council judged that the recent Cannock permission would lead to rebalancing overall. In the light of this, it minimised any concerns arising from Stafford and Sutton Coldfield. However, while Cannock would be likely to ease pressure on Stafford and the wider rural area to the north, it's at a distance from the main population centres of Walsall and Wolverhampton, and so less likely to have a direct impact on the demand at Streatley, let alone Sutton Coldfield. Moreover, Cannock has not been built, let alone started carrying out cremations. There remains uncertainty as to how it will perform. So that's what the inspector's conclusion was in relation to the issue, and and at 13.49, in relation to the Essington appeal, he said need from rebalancing at 13.48 under the heading need from rebalancing with regard to the green belt. Both appellants pointed to relief to crematoria further afield as a part of the wider planning balance. Dignity focused mainly on direct relief to Gornal Wood, while Westerly looked more broadly at Streatley and rebalancing to crematoria beyond. any benefits to Gornal Wood arising from rebalancing at Bushbury could be applied to both schemes. And then Westley also referred to increasing populations and death rates, including the area covering Walsall and West Bromwich, with significantly updated evidence since the last inquiry, which the council did not really address. If only one new facility is built, these increases are likely to result in comparable pressure as other crematoria. It follows that only through rebalancing the supply of services at a second crematoria would pressure comparable with that at Bushbury be avoided. And it was agreed that the consequences of chronic pressure at Bushbury would amount to very special circumstances. Taking account of rebalancing, the need for both proposals should mean that very special circumstances exist to justify both appeal proposals. Well, in the teeth of that conclusion and the Secretary of State's conclusion, could there be any justification for turning one's back on rebalancing post that decision on the 31st of March 2021?
It's clear from that decision and from the Secretary of State's endorsement of the inspector's report that rebalancing is entirely appropriate consideration and should be undertaken in circumstances like this where it's appropriate. So it endorses it.
If you had received this need statement had crossed your desk post 31st of March 2021, would you have let it go without suggesting that rebalancing be undertaken?
I would include rebalancing if I was doing the need statement post that decision.
Yeah, but in relation to the Reason News, you say that, in fairness, you did say, well, perhaps you should have undertaken rebalancing or suggested it in relation to the need statement. But what were the different circumstances that you had before you in August 2019 when it was pushed across or under your nose?
Well, I suppose there are two differences in circumstances. One is that there was no competing proposal at either Conisbrough or Barnaby done, and so the position at that point was rather more straightforward, although clearly Barnaby Moor was a proposal at that time, or it perhaps just opened, I can't quite remember which, but either way, that was sufficiently far away to not necessarily require rebalancing, but clearly now with Barnaby done, it does require rebalancing. And obviously, as of the 31st of March, there has been the decision from the Secretary of State which specifically endorses it.
Okay, good. Right, well, that I think deals with that issue. Well, sorry, just apart from this, I mean, you were here when I cross-examined Mr. Mitchell, and I mean, he was disarmingly frank about it, and he said he hadn't undertaken rebalancing.
That's correct. He did say that.
So what in your view, is how does that affect the weight that can be attached to his assessment?
Well, his assessment, it obviously considered the likely need in 2019, but it considers it on the assumption that Barnaby Dunn proceeds, but doesn't take a step back and look at the consequences of first Barnaby Dunn and then Brodsworth. So he doesn't attempt to undertake that exercise when I think he should.
And are you satisfied that a true rebalancing exercise was undertaken in the evidence presented by Memoria?
No, there was no attempt at a rebalancing exercise.
Good, thank you very much. The CMA report, please. And I mean, I'm not going to ask you to turn it up. You'll be relieved to know. But I just want to understand which end of the telescope the CMA view matters, and which end of the telescope you invite the inspector to view matters. What was the CMA seeking to make an assessment in planning terms as to what, even in general terms, as to how need arises and issues of, for example, rebalancing?
No, it wasn't. It was a report which had investigated the industry from a consumer perspective to assess whether the market was operating correctly or not.
Thank you very much. Yes, Barnby Moor, and this is the vexed question of whether or not there is evidence that that Rose Hill will lose out to the tune of 400 odd cremations, which will continue to go to Barnby Moor. First of all, will the inspector find any assistance by looking at the position on the ground now, absent Barnby Dun being there and absent an assumption in relation to your client scheme?
We're in an interim phase at the moment. Barnby Moor is trading. We have 1 year's results of it in the Directory of Crematoria, but it's not mature in itself, and we know that there will be a new scheme at Barnby Dun, and that the scheme at Barnby Dun will have a significant effect on Rose Hill. So the circumstances that are pertaining to the effect of Barnby Moor, which is quite some distance from Rose Hill, on the operation of Rose Hill, is clearly going to change when Barnby Dun opens. And the big change will be that whereas at the moment Rose Hill significantly overtrades, once Barnby Dun has relieved the pressure on it, it won't overtrade to anywhere near the same extent that it does at the moment. And therefore, it will be a more appealing opportunity for people living in the South Doncaster area once Barnby Dun's open than it is at the present.
Yeah, good. Thank you very much indeed. Now, some questions from Mr. Barrett. He made the point that that when you wrote the need assessment, so this is actually a point that comes from Mr. Barrett. He says, well, at that stage when he wrote it, Barnby Dun and the Horizon scheme were not in the picture. Is that a reason for or against undertaking a rebalancing exercise?
it's a reason for undertaking it now.
Yeah, thank you. Um, 10.2a, please, of your figure 10.2a of your proof of evidence. And the point here that Mr. Just make sure I got the right reference. Yes, 10.2a of your evidence. You were taken to that plan by Mr. Barrett to compare with the plan contained within Mr. Hodgson's proof of evidence, and I think the one that Mr. Barrett took you to was at figure map 5.1 on page 12. Is that right?
I think it was the, yeah, 5 point, yes, it was, yes.
But yeah, because both of them, well, certainly the map at 5.1 purports to show the 30-minute catchment area. Is that right?
Yes.
And the point that Mr. Barrett was making was, well, hold on to your horses. There is a significant difference between your 30-minute isochrones and those which had been adopted by Mr. Hodgson.
Yes.
I mean, on the face of it, I think you acknowledge that there does appear to be a difference. Now, what I'd like to do is just look at 10.2a, and because the 10.2a does include the 30-minute drive time in the red sort of spidery graphic. Yeah.
Yes. Yeah.
Can we also, it tells us at 10.10 of your proof that the darker shaded central area of the plan is the NCA of the proposed development. Yes?
Yes.
In terms of assessing impact, is your have your assessments been based on the 30-minute drive times or on the NCAs?
The assessment in Chapter 10 was based upon the NCAs. Neither assessment, sorry, actually, I'll qualify that. I apologise. The principal assessment, or the first assessment in Chapter 10, was based upon the NCAs. That's the scenario 1 and the scenario 2. I haven't used death information directly from the 30-minute CDA at all, but I have used the geographic extent of it in order to inform my assessment in scenario 3.
Which is your judgment in scenario.
Correct. Yes.
Yeah. Okay. So that's the rebalancing, obviously.
Yes.
Right. So so from the inspector's point of view, is she to be unduly troubled by the fact that you and Mr. Hodgson don't see eye to eye on what or don't present evidence which is necessarily consistent as to the extent of the 30-minute drive times?
Yes, I mean it's not ideal, but they're different. In reality, there's always going to be some difference, but I'm reassured in relation to my plan 10.2a, that the cross-checking that I did with the AA and other platforms in my rebuttal show that the distances to the crematoria in the Western are correct.
But what I'm seeking to establish is whether or not it in fact matters, given that your approach in relation to scenarios 1 and 2 was based on the NCAs.
It doesn't matter in the sense that both myself and Mr. Hodgson have based our assessments on the NCAs. It has the 30-minute area did inform my judgment in relation to the rebalancing, but it was.
And as we've already established, that judgment in relation to rebalancing, was that based on any mathematical equation or conclusion?
No, it was judgment.
Right, good, thank you very much. Then we had this Mr. Barrett's dog with a bone point about your approach of not actually starting with populations and then working down through populations to deaths and from deaths to cremations, and that in fact you explained that your approach was simply to go straight to deaths for identifying what the impact would be. If one has to undertake that exercise in the way that was being suggested by Mr. Barrett, in other words, starting with populations and then getting to deaths, how do you get from populations to deaths? What's the equation?
Well, the information on the NCAs is for population is readily available, as is the death information. So effectively, if there's a consistent mortality rate across the whole area, then the population information will be in exactly the same proportions between the NCAs as the death information. Clearly, mortality rates aren't the same everywhere, and therefore I think just to work on the basis of population figures is prone to the mortality rates varying. I just genuinely don't see the benefit in starting with population when when you've got the death information, which is the critical information.
So, I mean, did you see any purpose in including effectively an unnecessary complication of starting with population and then applying a factor to get to deaths, a factor which, in relation to any super output area, may change according to particular local circumstances?
No, I don't see the point in that.
Yeah. Yeah. I don't think. I mean, there were a lot of questions about that. I think the inspector will understand that point now. The tables, the dreaded direct cremations. You're going to come back. I mean, that's as an exercise in undertaking that. How long is it going to take?
As far as I'm concerned, there'll be for the inquiry tomorrow morning.
Right, good. Because we have to give the inspector, the other parties, an opportunity to say anything they wish to say about them, and the inspector will want that to be closed off as soon as possible, please.
Yeah.
Yeah, and then I think the final. Oh no, sorry. No, I said he was a dog with a bone, and I just need to go through some of the other points on that. You were asked about how you exercise your judgment on rebalancing. Now, as we've seen from the inspector's report and decision letter of the Secretary of State on works, there could be an approach of simply describing it, but that's not an approach that you have adopted. It's one that you've effectively undertaken the calculation. Is that right, Mr. Best?
That's correct.
Yeah, okay, so let's just have a look at how you do that, and I don't want to spend a lot of time on this very quickly, because I said it would be 40 minutes, 30 minutes indeed, and I'm already over that time. So we'll just try and wrap this up in the next 4 minutes, please. But just very quickly, can you just give the inspector the relevant paragraph numbers where she will find that in your proof of evidence, to where you describe the judgment that you went through?
Paragraphs 10.1 to 10.4, I basically explain the three scenario approach, and then paragraphs 10.44 to 10.51, I basically explain the approach in relation to rebalancing and the table for that.
Yeah, good. That's all I'm asking you to inspect to note. Thank you very much. Those are all my questions. That's all I have to ask you. Thank you very much.
Thank you.
Thank you, Mr. Village, and thank you, Mr. Best. Okay. Right, Mr. Robson.
Yes, ma'am.
Ms. Sudas is due to give evidence in chief.
Yes.
Are you in position to proceed with that?
Yes, ma'am. Mrs. Sudders, if you could turn on camera and microphone. Hello, Mrs. Sudders.
Hello.
Welcome to the inquiry.
Thank you.
If you just bear with me a moment, Mrs. Sudders, just while I close a number of documents and open up ones I will need for you. Ma'am, you should have Mrs. Sudders' proof of evidence.
Yes, I do.
And the appendix, I should say. There was also on this morning an errata sheet that was circulated, correcting a number of typos. I don't think there's a need necessarily to go through them. I hope you've received it, ma'am.
I have now, yes, thank you.
And the other parties as well. I'll take silence as yes. Mrs. Sudders, if I could introduce you then, please, to the inquiry from your proof of evidence at section 1. You are Andrea Suddies.
Yes.
You hold a master's degree in urban and regional planning, and you are a chartered member of the RTPI and currently hold the post of Principal Planning Officer at Doncaster Borough Council.
Yes, I am, and I do.
Good, thank you. You've worked in development management since March 2003, dealing with a range of different proposals, and you set out your site visits on the 10th of December 2020 and 6th of September 2021.
Yes.
Sorry to interrupt, Mr. Robson, you're not on my screen. I don't know if you switched your camera off or...
I'll turn my camera on and off again, ma'am, and see. Have I appeared?
That's better. Yeah, thank you.
Thank you. You state at your 1.4 and 1.5 that you will rely upon the evidence of Ms. Oxley for the assessment of the level of landscape and visual impact, and the assessment and the evidence of Mr. Mitchell for the assessment of the level of need for the appeal proposal.
Yes, that's correct.
You then state at 1.7 that you can confirm that the evidence given in this proof is true and has been prepared in accordance with the RTPI Code of Professional Conduct, that you understand your duty to the inquiry and have complied with and will continue to comply with that duty. You confirm that this evidence identifies all facts which you regard as being relevant to the opinions that you've expressed, and that the inspector's attention has been drawn to any matter which would affect the validity of those opinions, and that you believe the facts stated within this proof are true and the opinions expressed are correct. Could you just confirm that that's still the case, please?
Yes, it is.
Fantastic, thank you. I'd like to start, please, with the basis of the advice you gave to Planning Committee. And at the time, of course, there were 3 applications before them. Could you just start, please, then with setting out for the inspector the basis of that initial advice, please?
Ma'am, that's correct. There were 3 planning applications submitted for crematoria. The council took legal advice as to what they, how they should consider the applications, and the advice was that they should all be considered concurrently, as the issue of need was common to all 3. So based on Mr. Mitchell's advice, my advice to planning committee members was to make a recommendation of the most suitable location in terms of satisfying an identified qualitative and quantitative need for another crematorium. And the site best placed to meet the then current need was Barnby Dun. The issue of whether there was any residual need, this was also addressed by Mr. Mitchell, and his advice concluded that there was not sufficient residual need to grant 2 applications.
Thank you. It might help for this next part if you have the officer report in front of you, and you will find that at CD A6.
Yes, got that.
No, you were in attendance for the cross-examination of Mr. Mitchell last Friday. I think it was last Friday.
Yes, I was.
And the line of questioning from my learned friend, from Mr. Village, about the advice Mr. Mitchell gave with regard to the viability of Barnby Dun. And Mr. Mitchell was taken to your officer report, and specifically to section 9 with regard to viability and the impact that this scheme would have on Barnby Dun, with the direction of questioning being that there was a misrepresentation or an error perhaps in the officer report and the advice you gave. What do you say in response to that line of questioning about how you've interpreted Mr. Mitchell's advice?
Mr. Mitchell made reference to the viability, and I think the word he used was viability would be doubtful for 2 crematoria to be granted. I've taken this as a negative. Doubtful to me implies an uncertainty, a negative connotation. So in hindsight, maybe I've overstated his point. It certainly wasn't intentional. It was my interpretation of the word viability being doubtful.
If I could refer you then to 9.29 of your officer report.
Yes.
And you say both Conisbrough and Barnby Dun were developed. Would you like to read out 9.29?
If both Conisbrough and Barnby Dun were developed, Barnby Dun would not be viable. If Brodsworth and Barnby Dun were developed, Barnby Dun would not be viable. However, the point of issue here is that the Barnby site is the least constrained in policy terms, in that it is not located within the Greenbelt. Barnby is located within countryside policy area and is therefore the preferred location that would address the borough's need for a new crematorium.
So with that in paragraph in mind, were there other considerations before the committee, as well as potential impacts on viability?
Yes, there was. There was also a consideration of which was the least constrained in policy terms. Barnby was the best location to fulfil the existing unmet need at the time, both qualitatively and quantitatively, and it was also the least constrained by policy, being located within countryside policy area as opposed to Greenbelt.
And if you look at 9.22
yes.
of your report, please, perhaps read out 9.22, please.
The report evidences that the majority of areas within Doncaster with higher population densities lie within a 30-minute drive time of Rose Hill or Barnby. If only Barnby was operational, it would bring the highest number of people within a 30-minute drive time of a crematorium for the first time, 33,123. Developing this site would also result in the greatest population loss to Rose Hill at 64,926, or minus 32% of the current population for Rose Hill. Developing this crematorium alone would therefore provide the greatest impact on the current overcapacity at Rose Hill. This would improve the qualitative service at Rose Hill without affecting its viability. It would also bring the highest number of people within a 30-minute drive time catchment of a crematorium for the first time.
So in addition to policy constraints, what other considerations were you putting before the committee with regard to determining this application?
It was the proximity. It was the greatest number of people that were being brought within a 30-minute drive time catchment of a crematorium for the first time, and Barnby was the best location to be able to achieve that.
Thank you. I'd like to now look at Greenbelt, and if you could turn your proof up, please. At page 25. Which is your balance and conclusion section, section 9. And please, if you could read out 9.1 to 9.3.
The development would constitute inappropriate development and will harm the Greenbelt by way of loss of openness and permanence. It would conflict with Purpose 3 by representing significant encroachment into the countryside. The development would therefore cause significant harm to the Greenbelt in terms of its impact on the two essential characteristics of the Greenbelt and one of the 5 purposes of the Greenbelt. These harms should each be given substantial weight. The site is a scenic area of countryside currently devoid of built form and would involve a scale of development that would be better located outside the Greenbelt.
Thank you. When you use the term openness, what do you constitute it to include, please?
Well, there's no formal definition of openness, but I would consider there's a spatial and a visual element.
Thank you. So taking those in turn then, please, the impact on the spatial element of openness, what do you consider that to be?
Ma'am, there's the site and surroundings, they're currently devoid of any significant development or vehicular activity. The nearest dwellings are located 300 to 900 metres away, east of the site. The development of the appeal site of approximately 6.3 hectares with new buildings. The main building has a gross internal area of 743 square metres, height of 4.5 metres to the underside of the eaves. There's a chimney stack that would rise 1.8 metres above the height of the main building, substantial hard surfacing to accommodate a 500 metre length of access road and a large expanse of car parking to accommodate for 109 cars. There'll be external lighting, a pond, memorial gardens, and this would introduce a significant degree of spatial encroachment, which would, in my opinion, erode its openness.
Thank you. And then the impact on the visual element of openness, please.
Miss Oxley sets out the visual context of the site at paragraphs 2.14 to 2.20 in her evidence, and she comments that the site has a wholly rural agricultural character with no built form. There's no metalled roads, hard surfacing or lighting on site, and it's detached from residential properties on Green Lane or the nearest settlements. Vehicular presence is limited to farm machinery, and the development would result in an urban feel to the site with the building, hard surfacing for car parking, an access road with lighting, which would harm the visual aspect of openness.
Thank you very much. And then what is your final conclusion on weight, well, on harm to the openness and weight that should be given to it, please?
I afford substantial weight. That's in accordance with paragraph 148 of the MPPF.
Thank you. Now, you say in your 9.1 that the development would conflict with purpose 3 of retaining land within the green belt by representing significant encroachment into the countryside. Just please for the inspector explain your assessment on that element, please.
Well, ma'am, the long plantation forms the edge of a settlement. It's a ribbon-style development on Green Lane. The site lies further along Green Lane in a rural countryside location. It's devoid of any built form. And I agree with Mr. Kirkpatrick on encroachment when he stated in his evidence that it was the addition of an area or feature of either a building or hard landscaping. Therefore, building, access road, hard standing for parking 109 vehicles, removal of 180 metres of hedgerow would result in encroachment into the green belt. I would just add at this point for a clarification, the green belt review, it's Core Doc E8, I believe, was referred to by Mr. Kirkpatrick in his evidence. I just wanted to clarify the scoring. The site scores as a 3 in achieving the purpose of encroachment. It scores 4s and 3s overall in serving the 5 purposes. So the higher scores, i.e. the 4s and 5s, equate to a better performance in terms of purposes, and lower scores of 1s and 2s is harm to the green belt. Therefore, this site scores well. I just wanted to clarify that point because there seemed to be a little bit of uncertainty.
Thank you. Just so that we've got, and so that the inspector's got a clear note of that, perhaps if we turn up document E8, please, the Arup Greenbelt Review. And it's the Adwickler Street section, which is, sorry if you bear with me, this seems to be taking forever to load up on my computer. Do you have the page reference?
It is 110 of 355.
I've got that as Balby 2. So Adwickler Street. Bear with me.
It's page 17. So it's 100 of 355.
Aha, there it is. Yes. Adwickler Street 5.
Got it. Thank you.
Thank you. And so you were talking of the performance against purpose 3. So to assist in safeguarding the countryside from encroachment. If you could just give your answer again to my earlier question to the inspector so that we can note, or that it can be noted, what this document says?
So this site overall, in terms of achieving the 5 purposes, it scores 4s and 3s overall. I think it's 2 4s and 2 3s in serving the 5 purposes. The highest scores are, such as 4s and 5s, they are the better performance in terms of achieving the purposes, and the lower scores of 1s and 2s cause harm to the greenbelt. Because this site scores as a 3, it scores quite well, or it does score well.
Marked as a 3, and under purpose 3, we can see that there's the moderate sensitivity to development and score 3.
Yes.
Thank you. So, and what weight then do you give to the encroachment into the countryside? I
afford substantial weight to the encroachment.
Thank you. And of course, paragraph 148 of the framework requires that substantial weight is given to any harm to substantial weight is given to any harm to the greenbelt. Sorry, forgive me. The policy test, of course, requires the consideration of harm to the greenbelt and any other harm. You address this in your proof of evidence, starting at page 15.
Yes.
Dealing with landscape and visual harm, and it's paragraph 7.22 through to 7.46. Oh no, sorry, I've got that. It's 7.22 through to 7.30.
Yes.
If I could ask you, please, to read 7.29 and 7.30.
The adverse impacts on the landscape features and character and the adverse visual impacts, albeit more limited, represent other harm to be weighed in the balance. The proposal would lead to a loss of countryside in conflict with CS Policy CS3, which aims to protect and enhance Doncaster's countryside. It is also contrary to bullet point B of paragraph 174 of the framework, which seeks to recognise the intrinsic character and beauty of the countryside. I therefore attach significant weight to that harm.
Thank you. And you're here for the evidence of Ms Oxley and Mr Kirkpatrick and Mr Taylor. Is there any change to your assessment following that evidence?
No, there isn't. Miss Oxley assessed the site as having a moderate sensitivity, a landscape moderate sensitivity, so I don't think that weighting is inappropriate.
Thank you. You then go on to deal with very special circumstances. So we're on the other side of the balance now, looking at the benefits. And you, at 7.31, you give three components of considering benefits of the scheme. The first is need.
Yes.
And you stated earlier that you rely on the evidence of Mr Mitchell for assessing the level of need within the area. If I could ask you please to read out 7.40 to 7.44.
Mr Mitchell states in paragraph 1.7 of his evidence that 84.4% of Doncaster residents currently live within a 30-minute drive time of a crematorium. Barnby Dun will increase this to 94.9%. If Brodsworth were constructed and operated as well as the already approved Barnby Dun, it would then increase the percentage to 95.2%. He also advises that 98,069, that's 73.3%, of Brodsworth constrained 30-minute drive time catchment population would be Doncaster residents, but 29,604 of these people are already within the constrained 30-minute drive time catchment of the new Barnby Dun crematorium. In other words, these people are already served by Barnby Dun. In addition to diverting 235 annual cremations from Barnby Dun, Brodsworth combined with Barnby Dun would lead to a disproportionate reduction of 1,191 cremations per year at Rose Hill, severely impacting upon the viability of the combined crematorium and cemetery service. It is therefore evident that once the Barnby Crematorium is operational, the majority of Doncaster residents will live within a 30-minute drive time of a crematorium, 94.9%, and the addition of Brodsworth will only increase this by 0.3%. This clearly demonstrates that there is not a pressing significant need for another crematorium. Mr. Mitchell also considers that should Brodsworth Crematorium be granted consent, in addition to Barnby Dun, this would divert a combined total of 1,191 cremations away from Rose Hill and could severely impact upon the viability of Rose Hill. The Council's financial management has confirmed that the viability of Rose Hill would be seriously affected should Brodsworth become operational, in addition to Barnby Dun. Barnby Dun Crematorium would result in a £503,000 shortfall in income to Rose Hill. However, this has had to be accepted on account of the qualitative and quantitative need. Should Brodsworth become operational, this would result in a further £310,000 generated shortfall in income. Mr. Mitchell has, however, provided evidence that there is not sufficient residual need to offset the additional increase in the shortfall. The increased shortfall at Rose Hill is a material consideration that weighs against the proposal, to which I attach significant weight. And I also refer to Appendix 1, which is the letter from Finance Management.
Thank you. No, this was written, your proof was written before, obviously written before Mr. Mitchell's late evidence, for want of a better word.
Yeah.
Stuck in my head now. What change does Mr. Mitchell's later evidence have on your conclusions, if any?
On the basis of the new evidence, the impact on Rose Hill finances with the added diversion to Retford, that's the Barnby Moor and the Babworth site. If Brodsworth were granted consent, then there would be increased pressure on the council's financing.
Thank you. Now, we've heard a lot about the Western Arc, perhaps more about it than you were considering at application stage on the documents that were before you. What do you say is the impact on need, or what weight do you give to the impact on need of the Western Arc, please?
I afford that moderate weight. There is an impact on the Western Arc. There would be, looking at Mr. Mitchell's table in his original assessment, there's 105 cremations from Barnsley, sorry. There'd be 279 from Pontefract and 119 from Rotherham. Mr. Mitchell has already stated in his evidence that there will be a significant reduction in the amount of overtrading, so I afford a moderate weight to that consideration. I give it a moderate weighting because I consider that there would still be a significant overcapacity, i.e. it wouldn't be below 8%, so there would be no qualitative improvements. There would still be shorter cremation slots and wait times. Yes, this would take cremations off the Western Arc, but as there hasn't been a thorough alternative site search carried out of the Western Arc, it's not known if there would have been a better located facility within that Western Arc area. So in other words, the effect would be greater, or could be greater, on a better site, and there's little evidence that the appellants have considered sites to the west.
Let's look at the alternative site assessment then, and your evidence of it, and you deal with that at 7.47 to 7.53. Firstly, what involvement, if any, did the council have in setting that search area?
The council had no involvement at all.
If you turn to core document F14 at paragraph 6, F14 is the Department for Environment Plan guidance from 1978. And if we also turn up F15, which is the Federation of Burial and Crematorium guidance on the recommendations of the establishment of crematoria. Do you have both of those documents?
I haven't got the second document open.
Yeah, no problem.
Yes, got them.
Now, these guidance documents are both still extant. In fact, I think Mr. Lathbury refers to them in his evidence. First, you look at F14, the Department for Environment Guidance, paragraph 6, where it says care is needed in the selection of a suitable site for a crematorium, and the local planning authority should be consulted at the outset. And then F15, the Federation of Burial and Cremation Authorities guidance, page 2. Under the final heading, siting of a crematoria. Second paragraph, a proposed crematorium will require approval under the Town and Country Planning Act and current building regs. Therefore, the cooperation and sympathetic support of the local planning officer in the selection and layout of the site and buildings is highly desirable. Pre-application discussions with local authorities are highly recommended and are encouraged by government. Your pre-app response, was any issue raised about alternative sites, and was there any further involvement with the local authority in that process?
My pre-app advice, which was I think July 2019, it was clearly set out that they should carry out an alternative site assessment to establish sequentially if there were any other more suitable sites available other than this site within the Greenbelt.
Thank you. And an ASA was submitted with the application.
It was.
And we find that in document B8, the planning statement. We went to it briefly yesterday. And what are your comments about the appropriateness or otherwise of the submitted ASA?
My impressions and my opinion was that there was sufficient weaknesses within the site assessments that they'd done to question its validity. There were a number of issues that I would question about it.
Do you know when the alternative site assessment was carried out?
I believe it's in the planning statement. It does state 2016. So this was well before the pre-application advice in 2019. So my impression from looking at this was that the advice hadn't been followed. The site had already been selected.
And we note at paragraph 7.3 of the planning statement, there's a list of criteria there for the search or purported criteria for the search assessment. How do you assess the rigour that seems to have gone into the ASA with regard to the criteria?
There's no detailed explanation of the search criteria or the methodology of the site selection. They've sent out a site mailer to, well, there's 6 sites assessed. They sent out a site mailer. The appeal site doesn't fall within the search area. It isn't included in the assessment. Sites have been discounted on account there's no response received from a single letter sent in 2016.
Just pausing there. No response to a single letter sent in 2016. What more would you have expected?
I would have expected them to go out to site, look at each site. Well, to start with, I would I would have looked on Google Earth first, looking at Doncaster as a whole and looking for areas that fit with the Crematoria Act in the 200 yards, looking for sites outside of, or just outside of, settlements that weren't within the green belt. Then I would have contacted estate agents, any land agents, to see if there was any sites out there. I think that would have been my starting point. I would have also contacted the council. At Doncaster, we have a business Doncaster team, and this is exactly what they do. They look for sites for any developers, employment, housing, any sort of use. This is what they do. So they could have asked advice. They could have come to us. What I would have wanted would be to agree a methodology of the search criteria and how they would arrive at the sites, the selections.
Thank you.
Which they didn't do.
Was Barnby Dun, or where did Barnby Dun sit relative to the search area?
The search area, it's not easy to follow, actually. It's the boundary is not very well defined, so it's quite difficult to distinguish. But it looks like the Barnby Dun site is either just inside or on the boundary of the search area. Sites 5 and 6 that they show, I think it's in the proof. I'm not sure if it's in the
5 and 6
planning statement. Yeah, they're actually outside of the search area. From what I can distinguish, it looks like they're outside.
Thank you. And if you're in the planning statement, if you scroll down, please, to the Appendix 5, which is the plan that we went to with Mr. Lathbury. I think it was only yesterday, miraculously.
Which?
So in B8, CD B8, the planning statement, Appendix 5, page 91.
Yes.
And we see there the red dotted line on the key is identified as the site search zone.
Yes.
And then various different shadings taken from the policy map in the local plan at the time, not the current local plan, now adopted. And then Doncaster directly to the, probably just about to the southwest of the site, of the centre of that search area. So in terms of the geographical location of the searches, where was the, or which crematoria would you say that the search was targeting when looking at relieving overtrading?
Well, they seem to be looking at Rose Hill, proximity, concerned more with Rose Hill. There was no mention of the Western Arc within the application.
Thank you. Now, if we could turn up Mr. Williams's proof, please, and page 19.
Sorry, just bear with me.
Yeah, no problem at all. These the consequence of these virtual hearings is reliance on electronics to be as fast as we might hope. Are you there?
Yes, I am. Yeah, page.
It's page 19, and at section 6, he offers a relatively lengthy section about the availability of alternative sites outside the green belt. You see that? Yes. What comments do you have about this new alternative site assessment?
It seems a more thorough search. The search area, it's changed from the application stage from north of Doncaster to now include the Western Arc, and the only assumption I can make from that is because it seems to be retrofitting the site search to justify this site. Looking through the sites that have been selected, they seem to be relying on plan-led allocations or applications coming forward, and I've noted that they use the local plan housing and employment site allocations to look for sites, which I would question as to probably not being appropriate. Housing sites overall are not more than likely not suitable, as they're highly likely to be too close to housing to meet the 200 yards required distance in the Crematorium Act, and employment sites wouldn't be suitable. But the local plan sites, so I would question the use of looking at the local plan for these sites. The local plan sites were allocated as a result of site representations that were received following a call for sites consultation. They weren't as a direct result of the council carrying out a borough-wide search for sites, so they can't be considered a thorough search to simply rely on these allocations. So that would make me question the use of the sites that were allocated in the local plan, because it's just not a full search of the borough.
Thank you. Now, just in terms and summing up about the importance or the issues with the alternative site assessment, what do you say the inspector should take as the headline issues with it, please?
I think if they'd have used this methodology to find the appeal site, the one that they've used, well, for both the planning stage and the appeal stage, I would suggest that it's unlikely that they would have found this site. But if they'd have used the same methodology as they did to find the appeal site, it's likely that there would be other sites available. But like I say, the council wasn't approached with regard to the search for potential sites. And I think the importance of the alternative site assessment is that it shows that the focus wasn't the Western Arc. And based on that, my weight to contribution towards meeting the need of the Western Arc would include thinking about whether or not this was the best position. There's no certainty that there is no other suitably located site, so I would then afford this limited weight in the overall balance considerations.
Sorry, thank you, Mrs. Sudders. And then finally, with the planning balance, if you go back to your proof at page 26, please.
Yes.
And if I could ask you to read 9.6 to 9.13, please.
The economic, social and environmental benefits of the scheme put forward by the appellant overall do not weigh heavily in the balance in support of the proposal. The economic benefit of the proposal would be slight and is afforded limited weight. However, it would not harm the wider economy of the borough, and for that reason weighs in favour of the proposal, albeit only limited weight. The social benefit of the scheme relies primarily on the reduction of population travel times to a crematorium. The council's case on need shows that Brodsworth would be the closest crematorium for 133,786 people, 30,866 of whom would already be served by Barnby-Dun. Brodsworth would bring only 2,148 people within a 30-minute drive time of a crematorium for the first time. 84.4% of Doncaster residents currently live within a 30-minute drive time of a crematorium. Barnby-Dun will increase this to 94.9%, Brodsworth would only increase the percentage to 95.2%, an increase of only 0.3%. 98,069, that's 73.3% of Brodsworth's constrained 30-minute drive time catchment population would be Doncaster residents, but 29,604 of these people are already within the constrained 30-minute drive time catchment of the new Barnby-Dun Crematorium. In addition to diverting 235 annual cremations from Barnby-Dun, Brodsworth combined with Barnby-Dun would lead to a disproportionate reduction of 1,191 cremations per year at Rose Hill, severely impacting upon the viability of the combined crematorium and cemetery service. Whilst Brodsworth may be a viable crematorium for which I afford moderate weight, it is not the case that there is a pressing need for the provision of another crematorium. The social benefit of the proposal would be slight and is afforded limited weight. The environmental benefit of the scheme would be a net gain in biodiversity of 16%, and to which I attach significant weight. The benefits of the proposal, when considered together, do not amount to material considerations of sufficient weight to amount to very special circumstances that clearly outweigh the harm to the greenbelt and any other harm. The proposal conflicts with the development plan, and the material considerations advanced by the appellant do not justify determining the appeal otherwise than in accordance with the development plan. In conclusion, the proposal conflicts with the development plan as a whole and with national planning policy set out in the NPPF. The primary conflict of the proposal with the development plan is due to its conflict with policies CS3 in the core strategy and EMV3 in the UDP. This conflict arises from the location of the development in the Greenbelt and in the open countryside. The proposal also conflicts with Greenbelt policy in the NPPF, a material consideration with significant weight. I therefore respectfully ask the Inspector to dismiss the appeal.
Thank you. And just so that we're clear, where the references are there to CS3 in the core strategy and ENV3 in the UDP, those would now be replaced with the relevant policies in the newly adopted local plan.
Yes, there would be. Well, they are.
They are. Thank you very much, Mrs. Suddies. If you wait there, Mr. Village will have some questions for you.
Thank you, Mr. Robson. Would this be an appropriate time for a short break before starting cross-examination?
Yes, I believe it would. I think, Madam, that I'm going to be, I mean, I will see how we go, but I mean, I'm certainly going to take us up to 5 o'clock if I start at 4. And I don't know whether I will finish this witness this evening, but I stand by what I've said before about my overall time estimates in relation to the planning witnesses, because I'm not going to be repeating lines of cross-examination which I've already undertaken.
Well, I should be holding you to that, Mr. Village, and just be mindful of, not reducing other parties' cross-examination times either of your witnesses. So I shall hold you to that to keep to the overall timetable. So, I mean, I was going to suggest to come back at 5 to 4, just have a short adjournment. Is that okay?
Yeah.
Okay, we shall see you then. Thank you. Welcome back, everyone. So 5 to 4, I shall recommence the inquiry. Mr. Village, looking at the timings, I'm very concerned that there's going to be very little opportunity to catch up any time lost today if things do hang over till tomorrow. So I would like your assurances. I mean, obviously I have put your revised timescales in for tomorrow in terms of cross-examining you know, the council's witness, and I am concerned that we may not meet the timescale to finish the main evidence by close of play tomorrow.
Well, all I can do is give you my best estimates based on the materials I had at the time. I mean, this is a two-way process, and it's not all down to me, and I'm very sure that you appreciate that, because if new points are raised which weren't in proofs of evidence and so on, they have to be dealt with. And so, you know, I will do my best, but I won't repeat what I've already said before the short adjournment.
Okay, well, I shall hold you to what you said earlier about keeping to the timetable overall.
Yeah,
and without further ado, could you commence your cross-examination, please, Mr. Village?
Could someone just try and pull that line down, please? Just. Yeah, that's great. Miss or Mrs. Sudders, sorry.
Mrs.
Sudders, good afternoon. Is it any part of your case, or are you advancing as part of a new case that you wish to change the reason for refusal, which the single reason for refusal in this case?
No.
No. So the inspector can note that you are not seeking to change or add to the council's case as identified in the reasons for refusal, or reason for refusal.
This is a greenbelt location, and National Planning Policy Framework, paragraph 148, is quite specific in greenbelt considerations. When you're considering a development, it should be broken down into a balance of considerations, and any other harm is considered as part of that balance. And the landscape impact is within the remit of other harm and should be included as part of that balancing exercise. It quite clearly states that in paragraph 148. So not to include other harm, which in this case is landscape, in my opinion, would be remiss, which is why it's included in my evidence, and it's also in my committee report.
Mrs. Sudders, you've heard the injunctions issued by the inspector already in relation to timing, and I hope that the questions I ask are very clear and susceptible to a yes or no answer. By all means, qualify them. But I would be very grateful if you would now answer the question that I asked about almost 2 minutes ago.
I thought I'd just done that, Mr. Village. I thought I'd just answered your question. I'm sorry. I thought I had.
Okay. I'll put it again. Is it any part of your case which seeks to change or add to the council's case as identified in the reason for refusal?
The reason for refusal
Yes or no, really?
No, it's part of the Greenbelt consideration. I don't accept that it needs to be an entirely separate and independent reason for refusal within the decision notice.
It's a very simple question. Are you seeking to change or add to the council's case as identified in the reason for refusal?
We're not changing it. Other considerations should always be part of the balancing exercise, and that's what I've done in my committee report. That's what I've done in my proof of evidence. It's not itemised as a single reason for refusal, but I don't think it needs to be. There were sufficient harms to the Greenbelt. There were substantial harms due to inappropriateness, conflict with one of the purposes, and impact on openness. So there was no reason to include landscape.
Well, I think you're being unduly defensive here, because I'm not suggesting for a moment that there aren't, in considering the issue of Greenbelt, whether there are considerations of openness. I'm going to come on to the detail, but I just wanted to know whether or not it was part of your case that you should be able to add to it at this stage, either through your proof of evidence or subsequently. And I've now noted, tell me if I'm wrong, but so I can make submissions in due course, that you're not seeking to change or add to the council's case as identified in the reason for refusal. Am I right there? Is that correct?
The other issues, like I've already said, ma'am, the other issues should be part of the considerations within a Greenbelt site development.
I've asked the point 3 times. Madam, I'm now going to address the inspector, if I may. Madam, I mean, you know, this is a case in point, if I may say so, that you ask for you ask for time estimates, and we do our best, and we assume when we give those time estimates that we'll have very clear answers to clear questions. And if we don't get those, then I'm afraid time estimates inevitably will be derailed, and I make it clear now, madam, that if in response to a clear question I don't get a clear answer, or there's effectively, I mean, as I haven't now, even now, got a clear answer, then I regret that I think I'll be unable to meet that time scale. Mrs. Soddy's, the development plan policies referred to are CS3 and ENV and ENV2 and ENV3. And it's right, isn't it, that ENV2 is no longer relied upon?
Yes, that's correct.
Okay. In the statement of case, it's clear that the council's case fully set out in its statement of case?
I believe so, yes.
The landscape case to which you refer, and you referred to a few moments ago, is a case which you put in terms of the effect on the openness of the Greenbelt, isn't it?
In the statement of case?
In the reason for refusal, and in the statement of case. I'll put it another way if you like. There is no freestanding, leaving aside Greenbelt, there is no freestanding landscape impact or visual impact case. Leaving aside Greenbelt, there is no freestanding landscape or visual impact case, is there?
There's no standalone reason. It isn't in the reason for refusal, but like I said previously, I consider that the logic and the flow is that when considering the development overall, you break it down into a balance of considerations, and then the other harm is considered as part of that balance.
Okay, well, let's just to take it a different way. I was trying to help you actually there, that last question, but it doesn't seem to be that you aren't availing yourself of that assistance. But so I'll go back to the way I put it before. The landscape case that you put forward can only relate to issues of openness. It does not relate to issues of visual impact or effect on landscape character, leaving aside Greenbelt.
Not specifically referred to in the statement or the reason for refusal, but go back to my previous answer.
Okay, so are you saying therefore that if the inspector found that there were very special circumstances to allow inappropriate development such as this in the Greenbelt, but that there were also, leaving aside Greenbelt considerations and Greenbelt policy, there was a freestanding reason for refusing it on the grounds of visual impact or effects on landscape character? Would she be entitled to do that, in your view?
Sorry, can you repeat the question?
Let's assume for a moment that the inspector found that in Greenbelt terms, there were very special circumstances which overcome the harm to the Greenbelt by reason of inappropriateness. Mm-hmm. Would she be entitled, notwithstanding that finding, to refuse planning permission on the grounds, or should she, let me just, whether she was entitled, or should she, are you asking her to refuse planning permission on the separate ground that there will be a visual impact or that there will be a harmful impact on landscape character? Greenbelt aside.
I'm saying it should be taken in the balance.
No, well, you're
part of the balancing exercise.
You do a balancing exercise to understand whether or not development is should be, whether very special circumstances exist, and you undertake a balancing exercise. I understand that. What I'm interested to know is whether there is a freestanding. Do you know what I mean by freestanding?
I do.
A reason by itself. A reason by itself to refuse planning permission on the basis of visual impact.
If you're referring to the reason for refusal, no, there isn't a freestanding reason within the reason for refusal.
Well, there we are.
But I would add that the other harm, and I would consider the landscape visual impact under other harm, and that needs to be weighed in the balance as part of the balancing exercise for development in Greenbelt.
And that other harm only goes, in light of what you've just said, only goes to the issue of openness, doesn't it?
I think I would tend to disagree with that.
No. You see, you understand, don't you, Mrs. Sudders, that reasons for refusal have to be complete, precise, specific and relevant to the application.
Yes.
But it's a duty on the council to set out clearly what their reasons are, isn't it?
Yes.
Introducing new reasons for refusal at a later date could lead to an application for costs, couldn't it?
Potentially, yes.
Yeah. Are you introducing new reasons for refusal late in any respect in your case?
We don't think we are introducing any new reason for refusal.
So if it's not included in the reason for refusal, or indeed the statement of case, then it doesn't count. It's not an issue that you're relying on, is it, for the purposes of this case?
Ma'am, I think I would have to disagree with Mr. Village. Goes back to the balancing, the considerations, the balancing exercise.
So you disagree with me, disagree with Village, that if it's not in reason for refusal or statement of case, council can still rely on it. Is that the position?
As I said, I thought I'd consider that.
Yes or no, really, Mrs. Sudders? Is that the position? If I understood it correctly.
Yes.
Yes, thank you. Miss Oxley, your consultant, eschewed any suggestion that she was seeking to enlarge on the reasons for refusal. You heard that evidence, didn't you?
I did, yes.
In light of the answer you've just given me, however, that isn't the case, is it?
Miss Oxley didn't want to go into the realms of planning policy, I believe.
No, it's nothing to do with planning policy. The question is whether I asked her very clearly whether she was seeking to enlarge on the reasons for refusal. She said she wasn't. But that's in light of what you just told the inspector is in fact wrong, isn't it?
She didn't want to go into the reasons for refusal, I believe, because she was already assessing.
Enlarge on is what I said.
Sorry?
I said enlarge on. She said I said she eschewed any suggestion that she was seeking to enlarge on the reasons for refusal. But I said, in light of the answers you have just given, that is clearly wrong, isn't it?
I believe she didn't want to go into the reasons for refusal.
That's the question I asked. That's not the question I asked.
Sorry?
That's not the question I asked. I tell you what, I think I'm going to suggest, Mrs. Sudders, I will give you 3 opportunities to answer each question, and if you don't answer them, I'll simply move on, and we can then I can make representations in my closing submissions about the quality of your evidence. Mrs. Sudders, I'm going to move on because I asked you 3 times about that now. Mrs. Sudders, did you write the report to committee?
I did, yes.
Did you send a copy of it in draft to Mr. Mitchell?
Quite frankly, I can't recall.
You didn't seek any assistance from him about what you were going to say?
I believe I spoke to him. I can't recall if I sent the committee report. We just talked generally.
And
about the
sorry.
Sorry.
Yeah, you presumably discussed the issue of viability with him.
No, not particularly. No. It was. I thought I'd understood. I didn't. It was a case of we didn't discuss viability. We just went through which points, specific points, should be included in my committee report.
Well, viability was one of the most specific ones that was included in the report, wasn't it?
Well, that was clear in his report.
Yeah.
With regard to the reference that you're thinking with the my interpretation, his wording was viability would be doubtful. I've misinterpreted his meaning by that. I've overstated, which it wasn't a deliberate intention to.
Can I help you? Because you see, I don't actually think you should be blaming yourself, if I may say so, for interpreting the report in the way you did. So, I mean, I don't think it matters anyway, and I don't think actually this case is going to turn on that. So let's try and cut through that point. But I just wanted to find out whether or not you had discussed the issue of viability with him. And I suggest to you that if you were discussing what should go in the report, you would have said to him, I'm going to include the point that you make, that a granting planning permission would undermine the viability of Barnby Done. Did you make that point to him?
I can't actually recall what we spoke about in terms of viability. It was clear in his report, there were quite clear bullet points that the viability would be doubtful. So
it was put in a different way. We needn't go through it. I've asked him questions about it. We know what it says.
Right.
I won't. I'm taking issue with it. It doesn't actually say doubtful, but we can move on because the inspector can read what it says. Okay. 9.64 of your report, please. Now you wrote this, and you said that the council's urban design officers provided guidance and advice throughout the pre-application process and has been consulted with the subsequent application, commenting that the design of this proposal seems well considered in relation to the surrounding setting and could result in a good quality development which is sensitive to context and attractive in its own right. The officer is therefore satisfied with the scheme, subject to conditions relating to final materials, details of hard and soft landscaping scheme to be agreed, and 10% renewable energy requirement. You accepted that urban design officer's comments and indeed put it in the report because you agreed with it, didn't you?
in terms of the design, yes.
Yeah, good. And you also agreed with the conclusion of the actually, I'm not sure it was he in fact said this in his guidance, but you concluded that the development is therefore considered to meet with policy CS14 and the framework. Yeah.
Yes.
Could you turn up, please, CS14.
Yes, got it.
I haven't got it, but hopefully I will have it shortly. I don't know whether there's anywhere else I can find policy CS14. Sorry? Yeah, that would be helpful. Can I? Mine's just frozen. Thanks. So this is a design policy, and first of all, it starts all proposals in Doncaster must be of high quality design that contributes to local distinctiveness, reinforces the character of local landscapes and building traditions, responds positively to existing site features, and integrates well with its immediate and surrounding local area. Imaginative design solutions, including innovative and contemporary architecture, are welcome where they meet these objectives. New development should also have no unacceptable negative effects on the amenity of neighbouring land uses or the environment. This will be achieved through the design principles and quality standards set out below. And that is the policy that you said the proposal complied with, correct?
Yes.
Which includes a high quality design, which you agree with. It's a high quality design, isn't it?
I don't disagree with the design. I've no issue with the design.
You say you don't disagree with it.
Well,
the policy requires it to be a high quality design. You agree that it is a high quality design, don't you? The
urban design officer considered it was, and it was his opinion that I sought, his consultation.
No, you said the policy meets CS14. If it meets CS14, it has to be of a high quality design. And that's your view, isn't it, Mrs. Sudders?
I believe it would be, yes.
Yes. That contributes to local distinctiveness. Yes?
Oh, sorry, I didn't realise you were asking me.
Yes.
Sorry.
It contributes to local distinctiveness.
Well, that's clearly. I would, in hindsight, I would have to disagree with my recommendation that it complied with CS14.
Reinforces the character of local landscape and building traditions. again, you agree with that, don't you? Or you did agree with that?
Yes, purely on its design.
Yes, but it reinforces the character of local landscapes and building traditions, purely based on its design, you say. Responds positively to existing site features. Tick, correct?
Yes.
Yes, thank you. And integrates well with its immediate and surrounding local area. Tick.
It's a high quality design in itself, but not necessarily appropriate in this rural area.
Well, that's not what you told your members, advised your members, is it?
No, it isn't. And
I mean, you said in terms, or you quoted with approval, the design of this proposal seems well considered in relation to the surrounding landscape setting. Didn't you? That's what you quoted with approval.
That's what I quoted from the urban design officer that was looking at it purely from a design point of view.
And from with approval. You quoted it with approval. Yes.
Yes.
Now, in relation to viability, no case is advanced as a reason for refusal or otherwise relating to the effect of granting planning permission on Rose Hill, is it?
No, it isn't.
Yep. The fact, why do you say it is relevant that the council may not make as much money from the crematorium? Why is that a material planning consideration in the determination of this case, as opposed to purely a commercial consideration, which any landowner that owns a crematorium may have?
The Rose Hill Crematorium isn't like any other commercial crematorium. It's a council-run service relying on grant funding, and should Brodsworth be granted consent, it would impact on the service deliverability at Rose Hill, because there would be a loss of income. Rose Hill is a crematorium and a cemetery service, and they have to fund and fund the cemetery service and the upkeep of the cemeteries in and around Doncaster, and that comes from partly from the income at Rose Hill and partly from the government funding. And by the granting of Brodsworth would severely impact on that, and the grant funding, the loss in income would have to be subsidised from other areas within the council.
If it was a material consideration, why wasn't it raised as a material consideration in granting planning permission for Barnby Done?
It was taken into account in terms of, I believe, paragraph it's discussed in the committee report, but not in detail. But the main issue was whether there was a residual need, and that's why viability wasn't included, because it was more whether there was a residual need for a second crematorium to be granted consent. And the advice from Mr. Mitchell was that there wasn't a residual need, so viability wasn't included in a reason for refusal.
Well, no, Mr. Mitchell's advice was that if you granted a planning permission, it would impact on the viability of Barnby Done. That was his advice, wasn't it?
It was, yes.
Yes. But just going back to the grant of planning permission for Barnby Done, are you saying that the council in fact did take that into account, the effect on its own coffers?
No, the primary focus was to find, there was, Mr. Mitchell established that there was a qualitative and quantitative need for a crematorium. So the primary purpose, sorry.
I was just, sorry, I didn't want to interrupt you, but the question was, are you saying that the council did in fact take into account that the grant of permission for Barnby Done would have a deleterious effect on its coffers?
Not as part of the application. No, it was which was the best suited in terms of location to meet the existing unmet need.
Right. So and in fact we know, don't we, by looking at the figures, that Barnby Done has a greater impact on Rose Hill than does the grant of permission in respect of Brodsworth.
Financially. So
yeah.
Sorry, are you talking financially?
Yeah.
That was.
Well, in terms of cremation.
It. Yes.
Yeah.
Yes.
Yeah. Okay.
It would address the. It was the best place to address the unmet need, both in qualitative and quantitative terms.
That's a different point. I was simply addressing which has the greater impact financially. So the position is that, notwithstanding that granting permission for Barnby Done had a greater impact financially than granting permission for Brodsworth, it wasn't a consideration which the council took into account in giving permission to Barnby Done, but it should be a relevant consideration in whether or not to grant permission to Brodsworth. That's your position, is it?
Sorry, no, I misunderstood your last question. I thought you were talking in relation to the need. No, the original, the Barnby Done application, yes, there was going to be a significant impact on finances at Rose Hill, but Mr. Mitchell established that there was a qualitative and quantitative need, and that need had to be addressed. So the loss in income had to be withstood by Rose Hill. So in effect, no, it wasn't a consideration. It couldn't be, because there was an established need for a crematorium.
If there is a need in this case, then that wouldn't be a consideration either, would it?
It's I think this case is slightly, this is now a different situation. To grant a second crematorium would significantly impact on the finances of the service.
Well,
So
are you saying, therefore, that it does impact on the viability of Rose Hill? And because if it does, then what I will then be doing is pausing the cross-examination and asking the inspector for an adjournment to allow us to address that with new evidence, because that's an entirely new point. It's not raised in your statement of case at all.
no, it isn't. No.
Right. So are you raising that as a point in this case?
No.
There is, furthermore, no reason for refusal based on there being a sequentially preferable location or a failure to undertake an acceptable sequential search.
No, there isn't.
It would be unfair to the appellant for the inspector to refuse planning permission on the basis of a failure to undertake a proper sequential search in circumstances where that is not a reason for refusal, wouldn't it?
Surely that's got to be a consideration, I would say.
Well, why is it not raised?
It's not in the reason for refusal, but right. it is a consideration of whether or not this is the most suitable location.
Well, we'll come
in
on
terms
to the
of
detail.
meeting.
We'll come on to the detail of that either today or tomorrow, but I simply ask you, put the point to you again, you've made it clear that you're not raising the failure to undertake a sequential search as a reason for refusing planning permission. That's right. Yeah. The consequence of that concession is that it would be unfair to the appellant for permission to be refused if you're not asking for permission to be refused on the basis of the failure to undertake a proper sequential search, wouldn't it?
Using that logic, yes.
Yes. So far as the impact on openness is concerned, can you turn to 9.52 of your of the officer's report?
Yes.
It's considered, you said, that the development will result in some harm to the character and appearance of the landscape. This, I should just add, of course, is effectively your conclusion on this section. I mean, I ought to probably read it in fairness. In fact, it's helpful just to read 9.51. In summary, the consultant notes that none of the three application LVIAs conclude that the development would be of greater than minor importance, and does conclude that the landscape and visual effects of the three sites are likely to be similar. All three LVIAs conclude that the woodland and landscape proposals associated with the developments would be beneficial to the landscape and visual amenity to some degree. although in practice it would take some considerable time for planting to mature. Of the two sites located in Greenbelt, this application site benefits most from existing woodland, with views into and out of the site being limited to gated field access points within the existing hedgerow. Now, and I'll go on to the next paragraph in a moment. Just pausing there, the landscape and visual impacts of the three sites, you say, are likely to be similar. We know, of course, that Barnby Dun was not refused planning permission. It was granted planning permission. It follows, therefore, that the inspector can make a judgment based on that comment as to the extent of harm, if any, in landscape and visual terms from the appeal proposal, can't she?
I'm sorry, I'd have to disagree, because what you've read out there is Miss Oxley's overview of the submitted LVIAs, and they were just an assessment of what had been submitted. She didn't carry out her own landscape visual impact assessment. That's what she's done later at appeal, and she considers that there's a moderate landscape sensitivity.
Well, in fact, I cross-examined her on this. I'm not to go through it. She said what she said. It's all been recorded. We can view it at our leisure on YouTube. But she said there would be some impact on openness, but not to a large degree. And she said that the effect on openness was not for her, but was for was a matter of for the planners. Now, I don't understand you to suggest that the impact on openness is anything other than minor, and indeed that's what you said at 9.52, isn't it? It's considered that the development will result in some harm to the character and appearance of the landscape. However, this is minor. Significant weight is attached to this, however, given this is a green belt. Does that represent still your view?
That was written, like I said, on the basis of the overview of the LVIAs submitted, and Miss Oxley concurred that the effects would be less than minor. She's since carried out her own and considers that there would be more.
No, she didn't. In fact, give she declined to make a judgment on the impact on openness. Were you not here for that evidence?
In her own landscape visual assessment that she carried out, she did her own assessment. Yeah. And the landscape sensitivity was considered to be moderate. In terms of openness, impact on openness, she declined to make any judgment, didn't she? I can't recall. I'm sorry, I can't recall whether she did or not.
And your own judgment, you went on site presumably before you wrote this report.
No, I didn't.
What, you didn't go on any site inspection?
No, I didn't.
So let's be clear about this. Have you been on the site at all?
I have, yes.
When did you go on the site?
I went December last year, August this year, September this year. The reason I didn't go out to site was I was in lockdown for 3 months, 12 weeks. I'm classed as extremely clinically vulnerable, and medical advice to me was to shield, so I was unable to go on site. And I went on site at the beginning of December with planning committee, and that was against my medical advice.
I see. So this was written prior to you going on the site, but you did in fact go on the site in December 2020. Before the planning committee
Yes.
met. And the planning committee met virtually or in person?
In person. Sorry, no, it was virtually. Sorry.
Okay. In terms of, well, I may come back to that point in due course. In terms of the impact on the purpose of the Greenbelt, the only purpose that is identified is encroachment, isn't it?
It is, yes.
Now, I just want to understand your approach to the planning balance before we go into the detail of what points or what issues should be taken into account. Can you turn to paragraph 7.13 of your proof of evidence, please?
Yes.
Here you say the framework at paras 137 and 138 define the fundamental aim of the Greenbelt, its essential characteristics and 5 purposes. Development that adversely affects any of those causes, any of those causes harm to the Greenbelt. Paragraph 148 then allows substantial weight to be given individually to any of those harms to the Greenbelt. The use of the word any means that substantial weight should be attached to each individual harm to the Greenbelt. And then you go on at 7.21, in summary of the impact on openness of the Greenbelt and the purposes of including land in it. Paragraph 148 of the framework allows substantial weight to be given to any harm to the Greenbelt. This approach is endorsed at appeal. I therefore consider that the development represents inappropriate development in the Greenbelt for which I afford substantial weight. The development will result in harm to the openness, visual and spatial, of the Greenbelt for which I afford substantial weight. The development would permanently and significantly reduce openness of the Greenbelt, an essential characteristic for which I afford substantial weight. The development would encroach into the Greenbelt, thereby harming the purpose of preventing encroachment in the countryside, for which I afford substantial weight. I just want to understand your approach here. In terms of the planning balance, you consider, let's just assume for a moment, Mrs. Sudders, and you'll just have to bear with me here, that the inspector concludes that in terms of harm to the Greenbelt, in terms of the harm to the openness of the Greenbelt, it can be classified as minor. Okay? Your description in paragraph 9.52. Let's just assume for a moment that's her approach. If it is minor, I suggest to you that the proper approach is to give substantial weight to the minor harm, isn't it?
Yes.
By contrast, if she found that the harm was moderate, or if she found it was significant or even substantial, but let's use a different word, let's say moderate, for example. If she found the harm to the openness was moderate harm, she would give substantial weight to that moderate harm. That's the correct approach, isn't it?
It is, and that's the approach that I took in my proof of evidence. When I looked back at the weighting on my committee report, I looked at the weighting that had been attached to that, and I considered the weighting and whether or not it would have changed the recommendation with a different weighting. And it wouldn't have changed the recommendation. So I attach the significant weight in my proof.
And we can see that at paragraph 9.100, can't we?
Yes.
Where you say, although the impact on openness is minor, great weight must be attached to it as set out in the framework paragraph 144. Yeah?
Yeah.
Good.
Yes.
Well, that's very helpful, thank you, because you see, we have not clearly understood what you were saying in those paragraphs, but that's very helpful. In terms of impact on openness, in fact, where do I see in your evidence that you have changed your position from one of being minor impact?
In terms of impact on openness?
Yes.
Except paragraph 7.13 that you've quoted, that substantial weight should be given to any of those harms, where I'm saying that there is harm to openness.
No, you certainly say there's harm. That isn't in issue, but you don't quantify it. Where do you quantify the harm? Having previously, in the report to committee, advised members that the harm to openness is minor. Where in your proof of evidence do you quantify that effect, please?
It's not specifically quantified. in those paragraphs.
So there isn't, in fact, from you, contrary to what was said by Miss Oxley, that you haven't in fact addressed the issue of the extent of the harm to openness in your evidence at all, have you?
I think it's not specifying any, it's not giving an actual weight in terms of it's not specifying a specific amount of harm to the openness as picked up by myself reading through Miss Oxley's comments on the site, but I think I'm setting the scene of what's actually there. There's no built development, there's no built form, no metalled roads, no hard surfacing, lighting, detached from residential properties on Green Lane, which is sort of the nearest settlements or dwellings. Vehicular presence limited to farm machinery. So my conclusion is that it harms the openness.
There's no doubt that you conclude that it harms the openness. That isn't an issue. What is an issue is whether or not you quantify it in your proof of evidence. And you accept, I think now, that you don't in fact quantify it, notwithstanding that Miss Oxley said that it was a matter for the planners, didn't she?
I can't recall that, sorry.
You can't recall that. Okay. The only evidence, however, from before the inspector as to the council's view as to the impact of openness is in fact your paragraph 9.100, isn't it?
.100 in my committee report.
Yeah.
Mr. Robson, did you have a?
In fairness to Mrs. Sudders and in fairness to my learned friend, because I wouldn't want to put this in re-examination without, of course, him being able to make a point with Mrs. Sudders. This isn't necessarily a memory test, but 7.19 of the proof of evidence would say Mrs. Sudders would believe there is introduce a significant degree of spatial encroachment which would erode its openness. Of course, my learned friend is absolutely entitled to ask questions about that, but equally Mrs. Sudders has given her evidence in that way, ma'am.
Thank you, Mr.
That is in fact, that paragraph doesn't, and I mean that's if I may say so, a classic running to the aid of the witness during cross-examination, which my learned friend frankly is well beneath my learned friend. But that paragraph is not in fact, when properly read, identifying what the extent of the harm is to the openness. It says there'd be a significant degree of spatial encroachment which would erode its openness. It doesn't say what the effect would be on the openness of the greenbelt. It doesn't define it, and that's why Miss Oxley said that she would leave it to the planners to identify what the effects would be. And I was expecting to hear from you in your evidence in chief what you said the effects on the openness would be, but we didn't hear anything. And before Mr. Robson interrupted, you were unable to identify to me what you thought the effect on the openness would be, weren't you?
In terms of giving you the amount of
yes
harm.
Yeah.
I think it would be significant. You know, it's currently an agricultural field.
Okay, I see. So we go from minor in your report to committee, paragraph 9.100, to significant, do we?
I think I've explained, Mr. Village, the basis for my committee report and what that was based on and the judgment that was based on. Since then, Miss Oxley has carried out a full landscape visual impact assessment. And
declined on several occasions to identify what the effect would be on the openness. And indeed, it's not to be found in her original report either. So your position now, Ms. Sudders, I mean, 5 minutes ago, before Mr. Robson led you to that paragraph, 7.19, quite improperly, I think I may add. Before that, a few moments ago, you were unable to tell me or quantify the harm, weren't you?
I think there is significant harm.
You were
unable to
the openness. Quantify it 5 minutes ago.
There is significant harm to the openness.
But sorry, until Mr. Robson pointed that paragraph out to you, you were unable to quantify the harm, weren't you?
No.
Madam, that comes to 5 o'clock, and I'm going to move on to another point. I think it may be sensible tomorrow if we started a little bit earlier, because you'll appreciate, and I'm not going to say any more about it, but whether or not I am able to finish within that 2 hours that I hoped I would be able to is unclear. But just to give me the best opportunity to do so, I would perhaps suggest we start a little bit earlier, please.
Thank you, Mr. Villager, and that would be certainly preferable to finishing later, because I need to travel on Thursday evening, so I wouldn't want to finish much later than 5 o'clock. Just to take the views of parties on an earlier start, 9 o'clock, would that be acceptable to the parties?
Absolutely. From my perspective, I have childcare commitments from about 5:15, which I will seek to try and move this evening. But an earlier start is much better for me than a late finish.
Okay, thank you. Mr. Barrett.
Madam, I'm content with the 9 o'clock start. If it assists our timetable, I'm sure it will assist. And Mr. Village no doubt has an opportunity overnight to perhaps reflect and refine his cross-examination. He has done on every occasion thus far. I don't see why he wouldn't do so again. So it overall will assist, I think.
And is that okay with Ms. Sudders, as she will be in the hot seat?
Yes, ma'am, that's fine with me.
Okay, thank you. I'm just thinking through my childcare arrangements. I think it should be okay. If not, I'll let the case officer know. But yeah, I think it should be fine. Okay then. So, Ms. Sudders, just to remind you not to communicate with Mr. Robson overnight. It's not ideal to leave you hanging over overnight, but just to remind you of that. And are there any procedural or any other points before we adjourn today? Mr. Village, Mr. Wester is going to be putting in the updated calculations, so I shall expect those hopefully tomorrow morning. Yep, it's in hand.
They'll be with you before we start tomorrow, Madam.
Okay, that's brilliant. Thank you. Right then, if there aren't any other points, we shall adjourn until 9 o'clock tomorrow morning. Thank you very much.